Brenda Schleiss. I'm an estate planning attorney with the law firm Engermeyer and Rogers in Milwaukee, Wisconsin. In this video, I'm going to briefly discuss planning for financial and medical incapacity. When people come to see us about estate planning, they generally have a good idea of who they would like to receive what assets once they pass away. But if you're incapacitated, you're still alive, so to me that makes it the more important planning topic. I'll first discuss financial incapacity, and then we'll talk about medical incapacity. Incapacity for financial purposes means an impairment in the ability to receive and process information or to make decisions and communicate those decisions out. Financial incapacity means you're no longer able to make decisions on your own. When this happens, somebody needs to step in to continue doing those duties, such as managing your property, your finances, or business affairs. It also means doing day-to-day jobs such as opening your mail, paying your bills, and taking care of pets. The person you name to do these jobs for you is called your agent. You are called the principal. The primary tool used for incapacity planning is called a financial durable power of attorney. The primary tool used for incapacity planning is called a power of attorney for finances. This is the document we create that names your agent and lists what your agent can and cannot do for you. So we need to plan how the decision that you are incapacitated is made and who will step in to act on your behalf. Often we name your primary doctor or your treating doctor paired with your healthcare agent to make the decision that you no longer should be making financial decisions on your own. You can name multiple people to work together or just one agent. So frequently for married couples, we'll name the spouse as the primary agent and then name child number 1 and child number 2 to act as successor agents. Successor agents only step in if the primary agent is unwilling or unable to act. If you do use multiple agents or co-agents, we recommend you include language that allows them to delegate to one another, so that not every person has to sign every check or make every financial decision. However, it does allow the other agents to keep watch over the person who is signing checks and making decisions on your behalf. We also need to determine if there's someone other than yourself that you want to receive financial benefit during a period of your incapacity. For example, parents often wish their college students to continue to receive financial support if the parents become incapacitated. Similarly, adult children will frequently name their elderly parents to receive assistance if the adult child is unable to make that decision. If you don't name a person to receive this type of benefit, then you are the only person who can have financial assistance during a period of your incapacity, even if you were already helping someone before you became incapacitated. So it's an important point to think about and to write down in your financial power of attorney. Now, incapacity for medical purposes similarly means an inability to take in information and an inability to give out information to such a degree that it impairs your ability to make healthcare decisions. Unlike financial incapacity, in Wisconsin, the law states that 2 physicians or a physician and an advanced licensed practice clinician who personally evaluate you and sign a statement that you are incapacitated for healthcare purposes. Mere old age, eccentricity, or disabilities, whether singly or together, are not sufficient for a finding of incapacity. For example, my father was a very unusual person. People from the outside looking in would think that he was incapacitated, but I knew him, and I knew he was just eccentric, and eccentricity is not a finding of incapacity. Your healthcare agent takes over making medical decisions when you are unable to do so for yourself, whether due to illness or an accident. Unlike financial agents, for medical agents we need to first name one person, then another, then another. You may not name people as co-agents for a healthcare agent. So for example, for a married couple, we would name spouse as the primary agent, we name child number 1 as the successor agent, and we name child number 2 as a secondary successor agent. Again, a successor agent only steps in when the primary agent is unwilling or unable to act. When we're drafting a healthcare power of attorney, we need to consider your agent's ability to make life-ending choices on your behalf. Often we include language that says if something happens to me while I'm in an unacceptable medical state, then let me go, don't run the code, it's time to say goodbye. For example, if I have severe dementia, I no longer recognize people that I love, and something else happens, for example, my heart stops, I would say don't run the code, don't start my heart, so all I can do is come back and live with terminal dementia. So for your agent, you need somebody who's close enough to you to know what's unacceptable and acceptable, as well as somebody who's strong enough in their mind and emotions to make difficult decisions under pressure. Some people want to fight for every minute given to them, where others only want to live if they're comfortable and in possession of their right mind. So it's a terribly personal decision to make. For this reason, we often write our documents to give your agent a little bit of leeway so they can make decisions based on the facts they're facing at the time they're making the decision. You're not saying someone has the right to end your life. You're saying someone has the right to accept, maintain, discontinue, or refuse health care on your behalf. Sometimes people want to be too controlling in their healthcare powers of attorney, so we could potentially write documents that are hundreds of pages long, but inevitably there'll be some situation that's not covered. So what we recommend you do is trust your agent, give good guidelines, and talk to the person that you're naming as an agent. Talking with mom and dad about their end-of-life choices is a huge difference than standing in a hallway of a hospital reading a document, so talk to the person while you're still well. If you have questions or would like to discuss the topic further, please contact us at Angermeyer & Rogers for a complimentary initial consultation. We look forward to answering your questions.